Good morning, everyone. I am Sara Corradi, one of the judges of today. And yes, Peter, let me... Yeah, good morning, Peter. Good morning, everyone.
Hi, everybody.
Let me maybe have a chat with Delvin. And let's see if we can start. I think that... we could start. Because a lot of people are facing technical difficulty, I know.
Hi, everyone. I'm just checking in. This is Delvin speaking. Are we still waiting for some team members to join?
Good morning, Delvin. I just sent you an email. Actually, the second judge, Menar, is missing. We have Peter.
Yeah, we're trying to contact Manar.
Okay, thank you. And
I do have Peter. I'm sorry. Yeah, I do have Peter on the line. Peter, would you mind taking this session as well?
Yeah, that's fine. If you want me to, yeah, no problem.
Perfect. Thank you so much. Yes, Sarah. Sorry, you were saying something?
No, I would like just to ask the students if all the group are represented or if there are some students that are facing technical issues.
Yeah. Do we have everyone on the line for the team members? Because I see only 3 names.
Hi. No, my team member is facing a technical difficulty. She's trying to log in.
Yeah. Because is the other team member the one who starts?
No, I'm the one who starts for the
Okay, so maybe we can start with your submissions in the meantime until they have joined. Is that maybe an idea, judges? Is that maybe an idea to already start until the others have joined? Sorry, what, Peter?
Yeah, it's Peter. Yes, I think that's a good idea to just start.
Yeah. Okay, perfect.
If she is unable to log in, may I be able to take over her submission?
Yeah.
Okay, perfect. Thank you.
Just give me a second. Can you hear me?
Yes, Peter, I can hear you.
So, sorry, why didn't you start it? Do you want to? You're the lead judge. Do you want to start it? And
yes, I should start. Yes, we kindly ask to one representative, one of Middlesex University Team A, if kindly can start. I just would like to remember to all the students that you have 90 minutes each. The session will last 90 minutes, and there will be 45 minutes each team, and then we can have 10 minutes maximum for rebuttal. So I can ask you to the Middlesex University Team A if they can start. If you don't mind to turn on your camera and to say also your names, we'll start and best of luck. Can everyone hear me? Let me check in the chat. We have a new messages. Team A is here. Okay. So Fatima, you will be one of the council. You will start.
Yes.
Okay. Good morning.
My teammate Roshni will begin.
Okay.
Good morning
So
to you too.
Good morning. I will take the time.
May it please the court, my name is Roshni Mehreen and I appear as the senior appellant along with my co-counsel Fatima Zahra, and together we represent the claimant Mr. Leith Payne. I shall now provide your honor with a brief summary of the case facts. The facts are as follows. The appellant, Mr. Leith Payne, and the respondent, Ms. Raz Rani, are users of the platform called Clevity, where they trade cryptocurrency, Yapple, in accordance with the platform's essential terms and conditions of trading. The appellant resides in the Sultanate of Oman and the respondent resides in Dubai, not the IFC. And they each employ a computer program, Beta and Alpha respectively, and engage in algorithmic trading. Alpha purchases Yapple automatically at the best price offer, and Beta is set up to automatically offer Yapple for sale at a significantly inflated price if no other users are willing to sell it on the Clevity marketplace. Due to a glitch in Clevity software, there was a moment in which users with less than $200,000 were excluded from trading. As the only two users on the platform that had a cash margin above $200,000, the appellant and the respondent's trading algorithms were the only one allowed to trade. During this time, Beta offered to sell Yapple as it was programmed to do so, and Alpha agreed to buy it. The concerned party were unaware of the incident when it took place. Subsequently, the respondent filed a claim in the DIFC Digital Economic Court asking for a decision that the disputed trade on the transaction between the respondent and the appellant was void due to a unilateral error. The court found in favor of the appellant, Ms. Raz Rani. The appellant now appeals to the Court of Appeal on two grounds. I will now address your honor on the first ground of appeal, namely that the presence of Clevity's node within the DIFC server does not give DIFC jurisdiction over the disputed trade claim. I now make submission 1. Clevity's node in the DIFC is not the site of transaction. A node determines the legitimacy of transactions and furthermore saves and stores the transactional history. Judicial Law Authority Article 5 A, Section 1, Subsection B requires that contracts that are concluded, finalized, or performed within DIFC will allow it exclusive jurisdiction. But as stated earlier, neither of these acts could be fulfilled by a node. However, there are other requirements that could be met by a node in the DIFC that would allow it to determine jurisdiction. In the case of Ion Science Limited and persons unknown, cryptocurrency has been considered a property as per the High Court of Justice Business Property Courts of England and Wales Commercial Code. With cryptocurrency being viewed as an asset or property, it can be subjected to usual property laws, one of which is the concept of lex situs, in which the assets in question are subject to laws of the state in the location of the asset or where the person who owns them is situated. A node does not hold or store the cryptocurrency. It is simply a record of transaction. Therefore, its absence or presence in DIFC cannot satisfy the criteria for the application of lex situs. And an application of the latter criteria, the respondent's area of residence is not the DIFC, which is an independent jurisdiction, rather it is Dubai. There are other criteria that when satisfied could allow a certain state jurisdiction over the dispute. The central management and control test as established by Lord Loeburn in the case of De Beers Consolidates Mines Limited and Ho in the case in the year 1906 appeals case states that there are two requirements for jurisdiction. It must be located in it must be a location in which actual business takes place or the company resides for the purposes of income tax. These requirements cannot be fulfilled by a platform like Clevity, which has multiple nodes. And since nodes are merely devices authorized to keep track of the distributed ledger and serve as communication hubs for various network tasks, it is not the location of transaction. It is safe to say that actual business does not take place in a node like the one located in DIFC. And given the vast number of nodes a platform generally has, it cannot be held that a node represents a company's residence, since it would allow multiple state laws to allow and dictate matters of the cryptocurrency, as in this case, YAPL, and that would simply be unreasonable.
Hello, Ms. Shanawaz. Can you hear me?
Yes.
It's Mr. Smith. Could I just stop you there for a second? Let's look at the wording of Article 5A(1)(b). It says that the DIFC courts will exert an exclusive jurisdiction arising out of or in relating to a contract, where that contract is performed by conduct or an event which has taken place within the DIFC. So do you accept that the mere presence of one of these many thousands of nodes within the DIFC is sufficient to ground the court's jurisdiction?
No, because you cannot pinpoint a single node as the place of transaction for any transaction that happens within the Clevity software.
But doesn't that mean that it takes place within everywhere in the network, and so everywhere has a claim to this case?
What I think it's the court that is most like I'm not quite sure about the answer. I'm sorry.
Okay. So carry on then, you were saying.
Yeah. I now proceed with the second submission to further establish the points made earlier. An establishment can determine jurisdiction. However, since the node in DIFC is not an establishment, it cannot impact jurisdiction in the case at hand. Regulation 44 of 2001, Article 5, subsection 5 sets out that an establishment may establish jurisdiction. Essential characteristics and elements need to be satisfied by a body in order to be considered an establishment. The first requirement is that it must be an extension of the parent body in carrying out its main aim or purpose, in this case, carrying out transaction. Another element of the establishment is its appearance of permanence and a representation of legitimacy, as stated in the case of Somfer and in the year 1979, as reported in the Common Market Law Report. Since a node can be downloaded by any capable person, therefore, to be tied to the idea that a node is a representation of a company itself could be misleading. In conclusion, a node can neither satisfy the requirements of an establishment, nor can Clevity prove its location of residence as DIFC. Therefore, the presence of Clevity's node in DIFC cannot be a justification to grant DIFC jurisdiction.
Thank you. Can I just butt in and say, there's a doctrine in English law called forum non conveniens. The idea that even if a court has exclusive jurisdiction under its rules over a dispute, it might carry out a balancing exercise to decide whether or not it's the appropriate or convenient court. Would you, in your submission, would you be able to suggest other courts where this dispute could take place and whether or not they would be more appropriate? And I'm thinking here in terms of what would the substantive law of the dispute be? Where are the witnesses to this claim? What sort of documents and other information might be needed, and where are those things located? So which alternative court system would your client, Mr. Payne, say that this dispute should be heard in? I mean, I note that Ms. Razi is based in the Emirate of Dubai outside of the DIFC, and Mr. Payne, I think, is based in Amman. So I guess that a good start would be, as the resident of the parties is a common test for court jurisdiction. do you think that Dubai, outside of the DIFC, or Oman would be more appropriate?
Perhaps Dubai, since it probably has a framework that is more capable than what I have come across in like Oman courts with dealing with cryptocurrency, but I'm not quite sure.
Okay.
Okay, I have a question as well. You mentioned at paragraph 15, regulation 44 of 2001. Could you please better explain this citation that you did? Which...
I should say, I mean, I know Article 5 extremely well, having done 6 years of these disputes, that really only applies where a company claims to be based within the DIFC. And as I understand Ms. Shanawaz's contention is that neither Mr. Payne nor Ms. Razi are establishments based within the DIFC. I have to say, I think that's common ground between the parties. I mean, we accept that one's based in Dubai outside of the DIFC and the other's based in Oman. So I think that the ground of appeal is solely about the nature of the contract and whether it's to be partly performed within the DIFC. And Ms. Shanawaz says, well, we don't know where the node that processed the disputed trade is. And so we don't have sufficient evidence to say or to conclude that the contract was partly performed within the DIFC. Is that fair?
I agree.
Do you know of the de minimis test in English law? This idea that when something is so small, the English law just ignores it. Have you heard of that Latin expression, de minimis?
No, unfortunately.
All right, it comes up in things like rent disputes. I wondered if, do you think then, just thinking on your feet, whether or not a de minimis idea should be brought into this dispute? So for example, if you and I were to agree that I was going to sell you my car and we had nothing to do with the DIFC, but when we were talking about the contract, we just walked through the DIFC. Do you think that under the literal wording of Article 5A1 B or C, B, then the contract would, the negotiations of the contract would have something to do with the DIFC? But you would say, well, we just walked through the DIFC. I mean, you know, the property's not there, the car's outside the DIFC, neither you nor I live in the DIFC, and so on and so forth. Do you think that the judicial authority law should incorporate a de minimis idea?
Well, I don't think they should, because it's far more convenient to just claim jurisdiction based on where the contract is completed or fulfilled. And I feel like this would just complicate matters if it was this simple to claim that, you know, a certain area could have jurisdiction.
Okay. Thank you.
Thank you.
Sarah, are you still there?
Sorry, I was muted. Okay, if you are finished with Roshni, we can move to the second team, Middlesex J, if there is.
Hi, yes.
The council. Good morning.
Good morning. May I start?
Good morning, yes.
Okay. May it please the court, my name is Sahar Rashadat and I represent the respondent, Ms. Razrani. We have two submissions for your lordship and ladyship today. First, we contend that the Court of First Instance did not err in concluding that the DIFC court had jurisdiction over the claim by Ms. Raz Rani against Mr. Payne under the Article 5A(1)(b) of the Judicial Authority Law. Secondly, we contend that the First Instance Court did not err in concluding that for the purpose of a claim to avoid a disputed trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law that Ms. Rani shows that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that disputed trade was the result of an error. That the disputed trade was the result of an error. I will be addressing the first point now. I would first like to point out that following the four requirements set by the case of Provincial Bank versus Ainsworth to define a property, it was held in Rusco and Cryptopia Limited that cryptocurrency is a form of property. Furthermore, in the case of Ion Science, and Duncan Johns and Persons Unknown, Binance Holding Limited and Payward Limited, it was ruled that the jurisdiction of a case is decided based on where the owner is domiciled. Keeping these requirements in mind, we now turn to Article 5A(1)(b) of the Judicial Authority that states that the Court of First Instance shall have exclusive jurisdiction over any commercial claims and actions arising out of or relating to a contract or promised contract, whether partly or wholly concluded, finalized, or performed within the DIFC. My learned opponent has said that a node does not mean that the business was concluded in there, but as the judge has pointed out, a node means that the business has been possibly concluded in every single node that is present, like in the world. So that means that the DIFC node has been used to conclude the business, or partly, wholly, or concluded, finalized, or performed. So keeping these requirements in mind, we submit first that as the respondent is domiciled in Dubai, the transaction on her part was fulfilled within the DIFC node of Clevity, and that fulfills the requirements of Article 5A(1)(b) of the Judicial Authority, thus proving that the DIFC has jurisdiction. Alternatively, we would also like to submit that since the disputed trade made her the owner of the Yapple currency, which should be treated as property in accordance with the B2C2 limited case, she is currently the owner of the currency for the purpose of the test in the Ion Sciences case. Since she is domiciled in Dubai and the cryptocurrency is in a distributed ledger in the DIFC, we contend that the DIFC has jurisdiction over the case and it should be heard in the DIFC courts. Therefore, we contend that the decision made by the Court of First Instance was correct and request that the court dismiss this appeal. Thank you.
Okay, Ms. Rishadat, thank you for that. But can you tell me then, what do we know about the alternative venues for this dispute? I mean, why shouldn't this case be heard in the DIFC? Sorry, well, actually, you've just answered that. I mean, why shouldn't this case be heard in somewhere like Oman, which is where Mr. Payne is based, or indeed where your client is based in the Emirate of Dubai?
Because we believe that since the Judicial Authority states that the Article 5A(1)(b) states that any contract, whether partly or wholly concluded, finalized, or performed within the DIFC, gives jurisdiction to the DIFC, we believe that it automatically gives jurisdiction since the node is in the DIFC, right? So we don't think any other venue is appropriate, because when placing a node inside the DIFC, we believe that the platform Clevity had to have agreed to the conditions of Article 5A(1)(b).
Okay, so the Clevity intended the DIFC court to govern this dispute. Okay, thank you for that.
Thank you.
Okay, thank you. I have another question regarding round 2 of your submission. Could you be better explain the sentence that was cited in your paragraph 13 regarding the Singapore International Commercial Court? And if you can explain better to me, please, to the court, the concept that are at the base this decision of the judge, especially, of course, when we are talking about when you're talking about contractual concept in the doctrine of mistake, and how the court interpret the doctrine of mistake related to this specific case. Thank you.
Thank you for your question, Judge, but at this time, I do not have an answer for that. I will get back to you.
Okay. Well, thanks. We still have time for the second round for the junior counsel. I don't know if the team have the possibilities. Maybe you want to take 5 minutes with your team and you want to recap your ideas in order to be ready for the second part. We can leave you 5 minutes, and then we can. Here is 9:41. We can be back at 9:47, 9:50 if you want.
Yeah, that works. Thank you.
Okay. Both of the team. Yes. Thank you. Welcome back to everyone. Now I think we can restart from Middlesex University A with the senior appellant rebuttal. So I think Roshni, sorry for my pronunciation, if she's ready. I think she's not. She's
yeah.
Yes. So now, if you have some observation regarding senior respondent, what Sihan told us before, if you want to add something.
I'm sorry, can you give us a minute? Just a minute.
Observation regarding what was written in the submission and regarding what she said and what we discussed among us before. In terms of jurisdictions, first of all, if you have something to add in terms of jurisdiction and the ground of jurisdiction, and then in terms of the mistake, the nature of the mistake, the doctrine of the mistake, if you want to add something, if you want to make more observations regarding this.
I have nothing to add.
Okay. Okay, so we can move to the junior appellant.
Shall I begin?
Yes, please, Fatima, correct?
Yes.
Okay.
As my learned friend Roshni Mehreen Sayed had already established to the court that the presence of clavities note in the DIFC does not allow a jurisdiction to adjudicate the case. I, if the court will allow it, will now present the second issue. The facts of the case have already been expertly laid out for your convenience by my senior. Therefore, I will move on to make my submissions. Our second ground is that the judge erred in concluding that a unilateral mistake occurred in the disputed trade and that a reasonable trader with knowledge of the transaction would not continue on with it. Consequently, the judge erred in concluding that Article 37, Section 1, subsection A was satisfied. I submit that it was established in the case of Quene PTE Limited and B2C2 Limited, which was the second case decided in 2020 in the Singaporean Court of Appeal, that if an algorithm is programmed to make an offer based on an external order it received, and another is programmed to accept as long as it fits into the certain parameters set by the owner, then the contract is considered to be between two consenting parties. Here, the court shares the view that the automations are simply extensions of the human mind. The principle was established in Thornton and Shoe Lane Parking, reported in the second volume of the 1971 Queen's Bench Division Report on page 163 by Lord Denning. In his judgment, he goes as far as to compare the ticket machine to a booking clerk in disguise. Your Honor, this further accentuates the fact that any transaction between a machine and a man is a contract between the owner of the machine and the man. And as per the standards of fair trading, both parties are expected to keep the end of their bargain. It is therefore a viable conclusion that according to Article 37, Section 2 of the DIFC contract law, that the conditions for a unilateral mistake are unmet. Since my client insists that there was no mistake on his part when it came to programming his algorithm, and with the legal principles set in Quene, the automation, as with the owner, should have presumed the risk of mistake that would possibly occur in the world of crypto trading. This view is echoed by Chief Justice Sundaresh Menon. In conclusion, the conditions for a unilateral mistake to exist under Article 37, Section 1 of DIFC contract law are not met, and the contract between Mr. Payne and Mr. Azi remains valid. That is the end of my submissions.
Ms. Hisak, could I ask you, do you have Article 32 in front of you?
Article, one more time, sorry.
Sorry, Article 37. Do you have Article 37 1A of the contract law in front of you?
Just give me a minute.
It's probably your skeleton argument.
Yep.
We do. Paragraph 21 of your skeleton argument.
Right, Article 37.
Yeah, that's right.
I have.
Do you have it? You've only got that subsection 2. So 37.1, do you see it? Relevant mistake. A party, so in this case it's Miss Razi, may only avoid a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party, in other words, Miss Razi, would not have concluded it at all if the true state of the affairs had been known. So that's one part of the question. And the other party, so it's Mr. Payne in this case, made the same mistake or was also mistaken or caused the mistake or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. So let's leave out the contrary to reasonable commercial standards bit. Let's just ask if Mr. Payne made this, Mr. Payne, ... knew or ought to have known of the mistake. Now, do you think that we need to look at evidence about Mr. Payne's knowledge when programming the software, his beta software? Or do you think that because it's a reasonable person test, we can just presume that he anticipated at some point that the software might go wrong and these sorts of mistakes that led to disputed trade might occur?
I believe it is important to view the automations as I said before, extensions of the human mind. And as Sundaresh Menon, this Chief Justice, already said, the world of cryptocurrency trading is not for the faint-hearted. And it is obvious in crypto trading that there will be fluctuations in the market and other changes that can be unforeseen. And it's reasonable for any man who uses algorithm trading to assume that such sudden shifts in the market will occur, especially since over 90% of crypto trading is done by algorithms. So they should be viewed.
Yes, but I agree with you, Ms. Isaac. I see your point, or at least I see your point. But on the other hand, doesn't a trader, I think it's Mr. Boonen in the B2 C2 case, and Mr. Payne in this case, they're trying to make money out of gross fluctuations in the market. I mean, that's really what they do. That's why they create these algorithms to exploit the market.
Right.
So can't they just assume that any time there's an advantage, that's not an error, that's an advantage? It's a bit like in a football match. If the other side makes a mistake and you manage to slip through and score a goal, no one takes the goal away from you. They say, well, the other side's made a mistake. So from Mr. Payne's perspective, isn't it just the same thing, that the other side have made a mistake and it's not his fault? Why does he have to anticipate it?
I'm afraid I don't understand your question. Mr. Payne anticipated any sort of changes that would suddenly occur while he was programming, so that whatever happens, his algorithm will conduct a trade. He was willingly consenting to any sort of change in the market. That was his anticipation.
Yeah. Okay, not to worry. I think you put your client's case well.
Thank you.
Okay, thank you. We can move now to the junior respondent from Middlesex. J, please. Thank you.
Yes, thank you.
Good morning.
Good morning. May it please the court, I will be handling the second ground of appeal as well. Our second submission is that the court of first instance did not err in its judgment to, sorry, one second. Yes. Yeah. The first instance court did not err in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law that Ms. Razi shows that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. According to Article 37(1)(a) of the DIFC contract law, we would like to apply the reasonable man test, which states that what the reasonable person of ordinary prudence would have done given the defendant's circumstances in a negligence case. It is not relevant here what the defendant's thoughts were at the time of his conduct or the omission, since this is an objective test. So it is only sufficient to prove that what a reasonable man would have done in this situation. Based on this test, Ms. Rani, the claimant, brought a claim stating that regardless of the error in the software, Beta executed the transaction in accordance with the given conditions. In B2C2 Limited and Coin Limited, Judge Simon Thurley sets out the important guidance on how to apply the law of mistake in circumstances where legally binding contracts were performed by an automated contracting system without human intervention. The court had to decide how to determine the question of knowledge of the parties when transactions were carried out by computers acting as programmed. The court also had to consider whether cryptocurrencies constituted property capable of being held in trust and what remedies were appropriate for breach of contract or breach of trust involving cryptocurrencies. In 2018, the British Columbia Supreme Court in CopyTrack Private Limited versus Wall granted an order to mistakenly transfer cryptocurrencies. The court felt it was inappropriate to consider many of the substantive issues concerning the legal status of a cryptocurrency on a summary judgment application. The transaction also took place when both the parties were asleep, and as seen in Galaxy Edge International Limited and Novorossiysk Shipping Company, 2 Lloyds. It states that how emails could only be sent during working hours. As applicable to this case, the transition took place when both parties were asleep. Since the final transaction took place at night, the parties are held to be responsible. That concludes our submission. Thank you.
Okay, I'll start again. I think if you've got 37(1)(a) open, the question in this, I have to say, this is not an easy article to understand, but it's whether or not the other party, Mr. Payne, knew or ought to have known of the mistake. Now, you say that it's acceptable that the court didn't need to examine the state of mind of the programmer when designing the program. So you would say that you don't need to look at what he did in order to say that he ought to have known of the mistake. But do you think that's unreasonable and unfair? Because, I mean, you and I aren't computer programmers, and maybe why should the computer programmer be obliged to have anticipated the mistake when designing the program in order for the trade to be upheld? I know that's contrary to your client's position, but to look at it the other way, shouldn't the trade be upheld unless, maybe I would root it in your client's interests, but just as an understanding of 37(1)(a) and focusing very on ought to have known of the mistake, do you think that, I mean, these computer programs are bespoke. They exist in very narrow circumstances. You know, there's one for one market, one for one cryptocurrency, one for another.
Yes.
Isn't it the case that there's no such thing that a reasonable person or a reasonable trader with knowledge of the circumstances? I mean, isn't it the case that there's no such figment? I mean, that there's no such idea of a reasonable programmer who can look at the Singaporean case and this case and reach some sort of decision?
I don't think so. I think a reasonable person can be determined by basically what a reasonable person would do. We don't necessarily need substantive case law on it, because a reasonable person, we believe, would have anticipated this happening.
I should say that 37.1a doesn't actually have a reasonable person test. It's confusing because 37.1 talks about a party, a party, Miss Razi may only avoid a contract for mistake if, when the contract was concluded, the mistake was such of importance that a reasonable person in the same situation as Miss Razi. Okay, so that's one part of the test, and I don't think that that's the bit that we are focusing on, because 37.1a, because then it says, and A, the other party, made the same mistake, ... So in other words, the reasonable person test doesn't apply to 37.1a. It's that the other party, ... knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards. Because we know that Mr. Payne didn't make the same mistake, he wasn't mistaken, and he didn't cause the mistake. Do you see what I mean in 37.1a? We're not focusing on the first sort of 3 of the 4 subconditions. We're focusing just on knew or ought to have known of the mistake.
Yes,
And,
but we do believe...
No, go on.
Yeah, but we do believe that Mr. Payne ought to have known. So that is what we are focusing on right now, that he ought to have known of this mistake. And even if he did not know...
And you reach that conclusion not by examining his state of mind, but you reach that conclusion by just saying, look, we create this idea of a reasonable trader with knowledge of the circumstances around the transaction. Is that how you get there?
Yes, because looking at it like from an objective point of view, a reasonable person would not have made that transaction of 250
but
times.
Mr. Payne is an algorithmic trader. He's there to make money through instantaneous market transactions. And Miss Razi was there as well for the same purpose. If they had, I think you could say a reasonable person if, for example, Mr. Payne or Miss Razi had been involved in the transaction. So there's a human element to it. But they had both stepped out of the picture. They had set up their programs within parameters, and they didn't anticipate the mistake.
That is true, but I think we can extend it to Mr. Payne's software because he designed it and it was acting in his place. So I think we should extend the reasonable man, like what the program ought to have done. I think Mr. Payne should have included some safeguards against it.
Thank you.
Thank you.
Thank you, Sheha. Thank you, Peter. Now we still have time for junior appellate rebuttal, if there are. So I think Fatima. Thank you.
I can make them now.
Sorry,
I can make them now.
Okay.
All right. As Mr. Smith already said, the objective test that the respondent is quoting does not apply in our case, because our case actually pertains to whether a unilateral mistake was formed. And for a unilateral mistake to occur, there must be one party making a mistake on the aspect of a contract. So this is purely a one-sided mistake that happened from Ms. Rani that we say did not happen since she programmed the algorithm to act in a particular way. The instantaneous mode of communications as something that did not exist in the contract and thus invalidates it. However, this would not apply in our case because this standard only applies to human contracts between two men. However, the algorithm tradings are used to make up for human weaknesses. Therefore, the standard for instantaneous mode of communications, not giving consent to parties, it does not apply. That is our rebuttal.
Thank you, Fatima. Peter, do you have any questions for Fatima?
No, I don't know.
Okay. Me neither. So I thanks all the students who participated, and I think that's all for now. And then I think you will have your next round at 11, correct? At least University A, the sex I can see, sex A. Peter, if you don't have anything else to add, I will thank you, thank the students.
Yeah, I've got nothing to say. Yeah. Okay. Thanks very much, everybody.
Okay. Thank you, everyone. Bye.
Thank you, too.
Goodbye.
Thank you.